Hearing in the appeal, MB against Secretary of State for Work and Pensions.
Before we begin, Lord Pannick, I understand it is common ground that there should be an anonymity order in this case.
We've seen the draft that the court very helpfully sent to us, and we at the bar are agreed in inviting the court to make such an order.
Well, I will read it out so that everybody here present realises that the court orders that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of her or any member of her family in connection with these proceedings.
Thank you very much, my lady. I appear with Kerry Bretherton and Christopher Stothers for the appellant, and the Respondent Secretary of State is represented by Jason Koppel and Ben Lask. My lady, I've placed before the court an extract from the recollections of Jan Morris in her book Conundrum, published 1972, page 149, and the court will see on the right-hand side that she explains that after her gender reassignment in 1972, a courteous functionary explained to her that the question of my retirement pension would have to be settled nearer the time. Women get theirs earlier than men, and I suppose he thought I might change back again. Well, the issue has not yet been settled for this appellant. The question in this appeal is whether the appellant who underwent male to female gender reassignment was entitled in law to be treated as a woman at the age of 60 for the purposes of receiving a state retirement pension, even though she remained married to her wife, and even though she reached the age of 60 before the coming into force of the Marriage Same-Sex Couples Act. And our case is that the EU directive, Directive 79/7, confers on her a right to a state retirement pension at the age of 60 without the imposition of a condition as to marital status. The court will have seen, there's no dispute, a woman of the appellant's date of birth, which was 31st of May 1948, attained pensionable age at 60, and a man of that date of birth attained pensionable age at 65. So when the appellant reached the age of 60, which was on the 31st of May 2008, it mattered whether she was, for that legal purpose, a man or a woman. There's no dispute the appellant was registered male at birth. She had sex reassignment surgery. There's also no dispute she would have been eligible to be recognised as a woman for pension purposes when she reached the age of 60, but for her continuing marriage to her wife. They were married on the 21st of September 1974, and the statement of facts and issues, it's paragraph 6, states that the appellant and her wife are opposed to divorce or annulment on religious grounds. They do not wish to end their marriage. It's SC page number 69, and the core volume, it's tab 5, and it's paragraph 6. So there's no dispute about that. Can I take the court to the relevant provisions of the Gender Recognition Act 2004? The court should have two authorities bundles, and in volume 1 of that, at tab number 4, if the court is, members of the court, I see the Deputy President using the electronic version, it's SC page number 226.
Thank you.
That's the original Act, and it was amended after the enactment of the Marriage Same-Sex Couples Act, and that's tab 5, SC page number 278. But just dealing with the original Act, which is SC page number 226 at tab 4, the relevant provisions of this Act came into force on the 4th of April 2005. So that's before the appellant reached the age of 60. And if we look at the original Act, Section 1, subsection 1, a person of either gender aged at least 18 may make an application for a gender recognition certificate, GRC, on the basis of living in the other gender or having changed gender. And subsection 3, that application goes before a gender recognition panel. Over the page, section 2, in the case of an application, the panel must grant the application if satisfied that the applicant A, has or has had gender dysphoria, has lived in the acquired gender throughout the period of 2 years ending with the date on which the application is made, intends to continue to live in the acquired gender until death, and D, and this is the objectionable one, complies with the requirements imposed by and under Section 3. Section 2, subsection 3, the panel must reject an application if not required by subsection 1 or 2 to grant it. And then Section 3 sets out evidence. 1, an application must include a report made by a registered medical practitioner practicing in the field and the report made by another registered practitioner, or a report made by a chartered psychologist practicing in the field and a report made by a registered medical practitioner. 2 is some detail. 3, and subsection 1 is not complied with in a case where the applicant has undergone or is undergoing treatment for the purpose of modifying sexual characteristics, or treatment for that purpose has been prescribed or planned, unless at least one of the reports required include details of it. 4, an application must also include a statutory declaration by the applicant that she meets the conditions set out in section 2(1)(b) and C. And then subsection 6, any application under section 1(1) must include a statutory declaration as to whether or not the applicant is married. And I don't think the rest of section 3 matters. Then section 4, successful applications. If the panel grants an application, it must issue a GRC to the applicant. And 2, unless the applicant is married, the certificate is to be a full certificate. 3, if the applicant is married, the certificate is to be an interim certificate. And then section 5 deals with interim and full certificates. 5, a court which makes a decree of nullity granted on the ground that an interim certificate has been issued to a party to the marriage must, on doing so, issue a full GRC to that party and send a copy to the Secretary of State. And 2, if an interim certificate has been issued and either the person's marriage is dissolved or annulled, or B, the person's spouse dies within that period, the person may make an application for a full certificate at any time within the period specified in subsection 3, unless the person is again married. And subsection 3 sets out a period. Subsection 5, an application is to be determined by a panel. 6, the panel must grant the application if satisfied the applicant is not married and otherwise must reject it. 7, if the panel grants the application, it must issue a full certificate to the applicant. So the court sees that if you're married, you can obtain an interim certificate. It can only become a full certificate if your marriage is annulled or dissolved. A very simple statutory scheme. Then Section 8 allows for appeals. Section 9 deals with the consequences of a certificate, section 9.1, where a full certificate is issued to a person, I emphasise full, the person's gender becomes for all purposes the acquired gender, etc., etc. And subsection 2, subsection 1 does not affect things done or events occurring before the certificate is issued. The court will also wish to look at Schedule 2 to the Act, which appears on SC page number 243. And the only provision there that is relevant, I think, is paragraph 2. In section 12 of the Matrimonial Causes Act 1973, there is inserted a new ground on which a marriage is voidable. And a marriage is voidable if an interim certificate has been issued to either party to the marriage. Finally, under this Act, and there are other provisions that my friend wants me to refer to, Schedule 5, which begins on SC page number 255, the relevant provision in Schedule 5 is paragraph 7 on SC page number 256. Paragraph 7 is headed Category A Retirement Pension, and over the page, on page 257, at the top of the page, subparagraph 3, conversely, if immediately before the certificate is issued, the person is a man who's attained the age at which a woman of that age attains pensionable age but has not attained the age of 65, the person is to be treated for the purposes of section 44 of the Social Security Act as attaining pensionable age when it is issued. And so we are, Mr. Coppell and I agreed, it's not until you get your full certificate that for pension purposes you're treated as a woman. And therefore, there's no dispute between us that the effect of these provisions is that because the appellant remained married, indeed remains married, she was not entitled under the GRA until the Marriage Same-Sex Couples Act amended it. She was not entitled to a full GRC, and therefore, subject to the directive, her pensionable age remained 65. She, of course, attained that age on the 31st of May 2013, and so this appeal concerns her benefits for the 5 years prior to that. There is also no dispute, it's obvious, but there's no dispute, that the reason why English law included this marriage condition to which we object was because prior to 2014, same-sex marriage was not lawful in the United Kingdom.
Well, your objection is not so much to the provision itself as to its application to an issue which is unrelated to matrimonial status.
Precisely so.
Oh, one can understand why the Act passed in 2004 took that line, although it might have taken a different line had it been confident that the Civil Partnerships Act would actually reach the statute book, which is rather more controversial than the Gender Recognition Act, because obviously once you recognise that all the civil legal consequences of marriage can be acquired between persons of the same sex, well then it doesn't become as obvious that you should exclude
I respect
married people, I'm afraid.
My concession is simply that if one's attempting to identify Parliament's reasoning, Parliament was undoubtedly affected by the lack of legality of a same-sex marriage prior to 2014. My point, which is the point put to me by my Lord Sumption, is that we say that's not what this case is about. This case is about pensionable age, and it's about whether the appellant is entitled to be treated as a woman for pension purposes, not for the purposes of the law of marriage. And that's the distinction that I'm going to seek to develop in the context of the directive.
The real problem is, or part of the problem, is the statutory scheme depends on the concept that when the certificate's been issued, it changes the gender for all purposes.
Yes.
Maybe it didn't need to do that.
Well, if I'm
the all
right,
or nothing approach is the only approach which could be relied upon as justifying the discrimination.
well, if I'm right in my submissions on the directive, then the consequence would be that Parliament was obliged by EU law to distinguish between different consequences of the appellant being recognised as a woman. And our case only travels this far, that we say she was entitled under EU law to be treated as a woman for the purpose of pension law, for the purposes of identifying her pensionable age. And we're not concerned, we say in this case, with other contexts. And if there is a legal error by Parliament, as we say there was, it is in failing to distinguish different consequences.
But it's one thing to say that Parliament could have gone down the route of saying, for the purposes of your continuing marriage, you're a male,
yes,
but for the purposes of the pension, you're a woman.
Yes.
But you've got to go further than that. You've got to say that it was positively unlawful
Oh, yes.
for them to have taken
yes.
the contrary line.
Yes. I'm not seeking to persuade this court that it was desirable that Parliament took a different approach. My case is that my client was entitled under the directive to be recognised as a woman for the purposes of pensionable age. If I'm right in that submission, it follows that Parliament was acting unlawfully in doing what it did because it was obliged to follow through on that. So the question, I say the only question, is whether I can sustain my criticism under the directive. If I'm right.
No, you, as I understand it, you don't quarrel with the decision of the Strasbourg case and the Finland case. You say that's not the issue in this case. You're concerned simply with the directive and in particular Article 4.
Precisely. I recognise what my friend has said as to human rights law, and it's no part of our case to seek to persuade this court that we have rights under the Human Rights Act. Any such submission would come up against the judgments to which my friends understandably refer. I have to persuade this court that we're right under EU law, which of course is not something that the Strasbourg court was addressing. And I'll make submissions in relation to that. Now, this scheme that I've showed the court, enacted in 2004, was amended, and it was amended by the Marriage Same-Sex Couples Act 2013. And of course, that act made same-sex marriage lawful with effect from the 13th of March 2014. That's when the 2013 Act, its main provisions, came into effect. But in addition, the 2013 Act amended the GRA with effect from the 10th of December 2014. And the amended GRA is in the next tab, which is tab 5, SC page number 278. And if the court goes to section 4, which is on SC page number 290, bottom of SC page number 290, the court will see the amended section 4. There are various amendments which I don't think I need to take time on. It's not material to the issue before the court. But section 4 is amended in material respects. Section 4.2 is a new provision. The certificate is to be a full GRC if the applicant is neither a civil partner nor married, B, the applicant is a party to a protected marriage, and protected is defined by section 25 to mean a lawful marriage in this country or elsewhere, protected marriage, and the applicant's spouse consents to the marriage continuing after the issue of a full GRC, or B, or C, the applicant is a party to a protected civil partnership. The panel has decided to issue a full GRC to the other party to the civil partnership. So dealing just with marriage, after same-sex marriage becomes lawful, Parliament provides that for the purposes of your GRC, you will receive a full certificate if you're married, so long as your spouse consents. That's the new provision. That, of course, doesn't assist my client because it doesn't have retrospective effect. There's no dispute between us that that cannot assist my client in relation to the period when she was between the ages of 60 and 65, which is the relevant period. So that's the English law, the domestic law. The court will also wish to look at the directive, and the directive appears in the same volume at tab number 15. This is very familiar, of course, to the court, but can I just identify it? It's tab 15. It's SC page number 635. The principle of, it's headed the directive on the progressive implementation of the principle of equal treatment for men and women in matters of social security. Article 1 refers to the principle of equal treatment. Article 2 says that it applies to the working population, which includes retired or invalidated workers and self-employed persons. 3, the scope of the directive. It applies to statutory schemes which provide protection against the following risks, including old age. Risk is perhaps an odd expression to use in relation to old age. I suppose the risk...
Almost all members of this court would agree with you, yes.
Well, as I get older, I see the force of that. A certainty, unless unhappily one is deprived of it by fate. And Article 4... the principle of equal treatment means there should be no discrimination whatsoever on ground of sex, either directly or indirectly, by reference in particular to marital or family status, in particular as concerns a number of things, including the scope of the schemes, the conditions of access thereto. Article 5 requires member states to take all measures necessary to implement this, and Article 6 to like effect. Article 8 gave the United Kingdom and other member states 6 years to bring matters into effect.
The words you invite us to highlight are in particular, reference in particular to marital status. When you say that has been used as a yardstick for determining gender?
It's certainly regarded by the framers of the directive as an important indication. One still has to apply the provision to the circumstances of the case, but yes, my lord.
Yeah.
We have 2 points that I wish to develop. Can I just identify them and then seek to make submissions on each of them and respond to what I understand to be the main points taken against us? The first point is we say that the state cannot lawfully impose a condition under the directive when that condition is not an objective assessment of whether the appellant is, in medical terms or in psychological respects, a woman. The only conditions that can be imposed are conditions that seek to identify whether medically and psychologically she is a woman. And our objection to the marital condition is that it is additional to any assessment of whether she is a woman medically and psychologically. That's our first point. And our second point that I wish to develop is I say that the marriage condition is indirectly discriminatory against women. It has a disparate impact and it is unjustifiable.
Well, obviously, the framers of the directive thought that that would be the case.
Yes.
But it needs making good.
Yes, it does. It does. And I won't simply assert. I have to satisfy the court. Now, the question of how the directive applies to women who have undergone gender reassignment is a subject that has been looked at by the Court of Justice in Luxembourg. And can I take this court to the Richards case, which appears in Authorities Volume 2 at tab 24. It's SC page number 790. Authorities Bundle Volume 2, tab 24, SC page number 790. And the relevant facts, insofar as this court needs to know them, are set out at SC page number 813 in the judgment of the court. At paragraph 14, we see that Ms. Richards was born in 1942. She underwent gender reassignment surgery, and she applied, paragraph 15, she applied for a retirement pension to be paid from her 60th birthday, 28th of February 2002. The Social Security Commissioner, see paragraph 19, referred questions to the Court of Justice for a preliminary ruling. The questions were, does the directive prohibit the refusal of a retirement pension to a male to female transsexual until she reaches the age of 65, and who would have been entitled to such a pension at the age of 60 had she been held to be a woman as a matter of national law. My lady, my lords, I ought just to point out that the word transsexual is not now used. I mean, the community use the phrase those who have undergone gender reassignments. Matter, of course, for the court what terminology it uses, but the actual word transsexual is no longer used by those in that community. And if so, from what date should the court's ruling have effect? Paragraph 21, which is on SC page number 815, the court tells us, and I have to come back to this because it's the foundation of my friend's argument. Paragraph 21, first of all, it should be noted it's for the member states to determine the conditions under which legal recognition is given to the change of gender of a person. And there's a reference to the earlier KB case. So
you'll take us to KB, and of course you won't forget that KB takes us to Goodwin.
Oh, yes, indeed. Absolutely.
Very well.
Oh, absolutely. KB is Authorities, Volume 2, tab 23, and I will come back to that. Then paragraph 22, in order to answer the first question, it's necessary to state at the outset that the directive is the embodiment in the field of social security of the principle of equal treatment of men and women, which is one of the fundamental principles of community law. 23, the right not to be discriminated against on grounds of sex is one of the fundamental human rights, the observance of which the court has a duty to ensure. 24, the scope of the directive cannot thus be confined simply to discrimination based on the fact that a person is of one or other sex. In view of its purpose and the nature of the rights which it seeks to safeguard, the scope of that directive is also such as to apply to discrimination arising from the gender reassignment of the person concerned. And that's an important statement of principle. There's a reference to the equal treatment case of P and S, to which I will also come in a few moments. I don't think I need to read 25, 26, and 27. 28, the unequal treatment at issue in the proceedings is based on Miss Richards' inability to have the new gender which she acquired following surgery recognised with a view to the application of the Pensions Act 1995. And this was before the coming into force of the GRA. 29. Unlike women whose gender is not the result of reassignment surgery and who may receive a retirement pension at the age of 60, Miss Richards is not able to fulfil one of the conditions of eligibility for that pension, in this case, that relating to retirement age. Over the page, 30, as it arises from her gender reassignment, the unequal treatment to which she was subject must be regarded as discrimination which is precluded by Article 4 of the directive.
So it's evident from 29, and I think explicit in the Advocate General's opinion, that the comparator being taken in this context is somebody who was biologically woman from birth.
Yes, someone who was born female is in a better position, and therefore there is sex discrimination for the purposes of the directive because Miss Richards is treated less favourably by reason of the fact that her status, her gender, is dependent on gender reassignment and not the sex, the gender that she had at birth. That's paragraph 30.
One argument against you is that your case would treat your client more favourably, viz., your client would be able to remain married to a woman, whereas a woman biologically so from birth wouldn't then have been able to marry a woman.
Yes?
What do you say about that?
Our answer to that is that a woman who has that gender from birth is not subject to any marital condition for the purposes of determining her pension age for pension purposes. It is simply irrelevant what her marital status is. And our objection is that in the context of a person who has undergone gender reassignment, a marital condition is imposed. That's our objection. I understand the point your lordship puts to me. I say it with respect. I say it's the wrong question, with great respect. It's the
quite
wrong
different
question
point, isn't
my
it?
friend is putting.
Yeah. I mean, there are some of the ways in which you've just been putting it suggest, which I have not understood to be your case, that the discrimination arises from failing to recognise the medical or psychological status of a person. Whereas, I mean, there are two completely separate arguments, aren't there? One is based on the alleged discrimination involved in not recognising somebody as a woman at all, and the other is related to the introduction of a marital status criterion. I mean, those actually give rise to two logically quite distinct issues, and the first one may be easier to justify than the second.
Well, we are making both objections.
Yes, but you accept that they're distinct objections.
Well, logically, there are different questions, but our objection under the directive is that we say the appellant, having undergone gender reassignment, has a right not to be treated less favourably than a person born female for the purposes of pension law, which is all we're concerned with. That's our case. And we say it is a denial of the purpose, a frustration of the purpose of the case law relating to gender reassignment and equal treatment, not to recognise my client as a woman for this purpose, given that she is medically and psychologically a woman. That denies her the dignity and the equality which it is the purpose of this area of the law to respect. And I'll show the court the case law, which I say supports that. But before I come to that, can I just complete what Richards says, because Richards then concludes at paragraph 38, this is on SC page number 819, it's clear from the foregoing that Article 4.1 must be interpreted as precluding legislation which denies a person who, in accordance with the conditions laid down by national law, has undergone male to female gender reassignment. And there's no doubt, I emphasise, my client has, in accordance with the conditions laid down by national law, undergone male to female gender reassignment, entitlement to a retirement pension on the ground that she'd not reached the age of 65 when she would have been entitled to such a pension at the age of 60 had she been held to be a woman as a matter of national law.
Lord Panic, you said that your client underwent male to female gender reassignment in accordance with national law. I had rather understood, perhaps misunderstood from the Gender Reassignment Act, that actually, for these purposes, you didn't need to have any sort of surgical operation.
That is correct.
So when you said it's all been done in accordance with national law, national law doesn't require it, does it?
But national law doesn't require it. National law allows, through the National Health Service, people to have gender reassignments.
Well, now you're clarifying.
That's all.
Very well.
And I apologise, my use of language was inappropriate.
Very well,
Your
Lord
Lordship
Penny.
is absolutely correct. One can obtain a certificate under the 2004 Act without undergoing any surgery of any sort. In this case, and that may lead, depends on the circumstances of the case, it may lead to questions whether the panel is satisfied that the person is medically and psychologically a woman. And no doubt there are difficult cases that will arise. This is not one of them. So that's the case of Richards, and it is one of the interesting features of Richards that, in fact, at the relevant time, Miss Richards was married. There's no mention in the judgment of the Court of Justice, no doubt because neither side thought it had any relevance at all. But if the court looks at the later Court of Appeal judgment, if this court looks at the later Court of Appeal judgment of Timbrell, which appears in Authorities Volume 1, tab 11, SC page number 482, this is a similar case to Richards in the domestic context, again before the GRA comes into effect. The judgment of Lord Justice Aikins for the court begins at 484, and this court can see at paragraph 1 that the circumstances are very similar to Richards, and indeed to this case. We're dealing with an appellant who's born male. In the case of Miss Timbrell, she marries, she has children, she then undergoes gender reassignment surgery. The couple decide to continue to live together as a married couple, they remain so, and then the problem arises as to pensions at the age of 60. And over the page in paragraph 5, there's a reference to the Richards case. And in paragraph 5, in the second sentence, Miss Richards, previously a married male, had undergone gender reassignment surgery. She remained married thereafter. So Miss Richards is married, and I shall be making a submission by reference to that. And the same is true as the court sees in Timbrell. Now, can I then come to our first ground and the submission that the power of the member state under the directive to impose conditions on the recognition of a person as a woman after gender reassignment is, we say, limited to conditions which address whether, as a matter of medical fact, and psychology, the person is now a woman. And we therefore have no objection, could have no objection, to the main criteria set out in the 2004 Act. Most of the matters, most of the criteria and the evidence do go to whether the appellant is now, or rather the applicant, is now a woman in medical and psychological terms. And our objection to the marital condition is that it is not concerned with whether the person concerned is a woman in medical and psychological terms. It's imposing an additional requirement. I ought to be very clear about this because my friend has understandably taken a point in his printed case, it's paragraph 43, that we in our printed case had suggested that the power to impose conditions is confined to conditions relating to gender reassignment surgery. And I entirely accept the criticism that was too narrow a definition of the conditions that may lawfully be imposed. On reflection, having considered the matter in the light of what my friend says, I entirely accept that it must be open to the state to impose conditions which address whether the appellant is, in medical and psychological terms, a woman. That I can have no objection to. I also do not ignore the fact that marital status may, I say may, be relevant to an assessment of psychological status under the Act. I recognise that may be so. What I say is that it is a different matter to impose a marriage condition, an absolute marriage condition, as a requirement additional to an assessment of medical and psychological facts. Now, we say that to permit the state to impose conditions which do not address whether the appellant is a woman medically and psychologically would conflict with the object of the law in this context. And the object of the law is to protect the dignity of the person who has undergone gender reassignment and to prohibit her being treated in this context less favourably than a person born into the female gender. And we have a fundamental objection, with great respect, to the approach of the Secretary of State. And can I take the court, please, to my friend's printed case, the respondent's written case, which appears in the core volume, tab number 7. It's SC page 92, that's where it starts. And the passage that I invite the court to focus on begins on SC page number 110. At the bottom of the page, there's the heading, Discrimination on Grounds of Sex. And at paragraph 57, in the second sentence, the Secretary of State accepts that a condition laid down by national law for the legal recognition of a new gender, which is in turn a precondition to the obtaining of benefits falling within the scope of the directive, must not discriminate on grounds of sex. We agree. The marriage condition, says the Secretary of State, did not do so. And then it's this: it did not discriminate directly on grounds of sex. Why? Because both male to female and female to male transsexuals were subject to the same condition. And then my friend moves on to indirect discrimination. Now, I say, with respect, that involves a fundamental misunderstanding of the nature of direct sex discrimination in the present context. And the reason why it is a fundamental error is because it was the error made by the United Kingdom in the first case in the Court of Justice addressing gender reassignment and equal treatment. And I refer to the case of P and S, which this court will find in volume 2 of the authorities, tab 21, if I could invite the court's attention please, tab 21, it begins on SC page number 691. This was a case under the Equal Treatment Directive. P was undergoing sex reassignment and was dismissed by the employer. And the question was this a breach of the Equal Treatment Directive? P was dismissed because of the gender reassignment. And the Court of Justice, in its judgment beginning at paragraph 14, it's SC page number 712, paragraph 14, sets out the United Kingdom's argument. It was supported by the Commission, in fact, in that case. SC page number 712, paragraph 14, the United Kingdom and the Commission submit that to dismiss a person because he or she is a transsexual, or because he or she has undergone gender reassignment operation, does not constitute sex discrimination for the purposes of the directive. 15. In support of that argument, the United Kingdom points out in particular that it appears from the order for reference that the employer would also have dismissed P if P had previously been a woman and had undergone an operation to become a man. The very point that the respondent's written case is now advancing. 16. The European Court of Human Rights has held that the term transsexual is usually applied to those who, while belonging physically to one sex, feel convinced they belong to the other, etc., etc. At 18, thus the directive is simply the expression in the relevant field of the principle of equality, which is one of the fundamental principles of community law. 19 is to like effect. 20, accordingly, the scope of the directive cannot be confined simply to discrimination based on the fact that a person is of one or other sex in view of its purpose and the nature of the rights which it seeks to safeguard. The scope of the directive is also such as to apply to discrimination arising, as in this case, from the gender reassignment of the person concerned. 21, such discrimination is based essentially, if not exclusively, on the sex of the person concerned. Where a person is dismissed on the ground that he or she intends to undergo or has undergone gender reassignment, he or she is treated unfavourably by comparison persons of the sex to which he or she was deemed to belong before undergoing gender reassignment. 22. To tolerate such discrimination would be tantamount, as regards such a person, to a failure to respect the dignity and freedom to which he or she is entitled, and which the court has a duty to safeguard. And I emphasise that passage because that is the foundation of our argument. We say that to impose conditions on recognition of my client as a woman, which are additional to conditions which relate to whether she is, in medical and psychological terms, a woman, would be fundamentally to deny the dignity and freedom to which she's entitled under this directive.
It's interesting, paragraph 21 appears to be drawing a comparison with a person of the previous gender rather than
In that
with,
context, yes,
with a person of the acquired gender.
Your Ladyship is absolutely right. That I anticipate because in that case, the appellant had been dismissed, and so she was being dismissed in circumstances in which someone who, like her, had been born male, who was not undergoing gender reassignment, would not have been dismissed by that employer.
It could equally be said that if she had been born female, she wouldn't have been dismissed.
Indeed.
Doesn't really matter.
No, it doesn't matter in the circumstances of that case. The point, sorry, my lord.
Well, Advocate General Jacobs addressed this very point.
Indeed he did. I'm
Noted
coming to
this
him.
point of distinction. You're going to come to
I
that.
am indeed, my lord. Yes, I'm coming next, I
The
think.
context of this case is slightly different, isn't it? Because in this case, I'm not had a very quick look at the facts, perhaps not an adequate one, but in this case, it was the fact of gender reassignment that was the ground of dismissal.
Yes, it was.
Whereas we are concerned with a problem arising not out of the fact of gender reassignment, but about the gender itself.
Yes.
It may be that the reasoning is a little more difficult to apply in a case like ours.
I entirely accept that point. P&S, as the origin of this area of jurisprudence, was an easy case because the objection in P&S was that the individual was dismissed from the job because she was undergoing a process of gender reassignment. That's not the issue.
Not because of the gender that she ended up with.
No, it was irrelevant to P&S to identify which gender she had. That wasn't the issue. And of course, in our case, the legal issue, I entirely accept, is to fix for legal purposes my client with a gender for the purposes of the Social Security Directive. But I'm relying on this case for two reasons. First of all, because the process of analysis by the Court of Justice is entirely inconsistent with my friend's analysis of what direct sex discrimination means in this context. It is simply not the law that one identifies whether there is direct sex discrimination by asking the question whether my client would have been treated more favourably had she started off as a woman and become a man. That's simply not the question. And P&S makes that very clear indeed. And it made it very clear, no doubt because of the inadequate arguments made by counsel for the United Kingdom in that case. He did his best. But that's the first point. The second point, the Lordship wondering what I'm talking about.
Yes.
We can guess.
We can guess.
We can guess.
160. The court may have seen. And the Advocate General in that case, the court may also have seen, invited the court to take, I think the word used was a brave decision. I mean, it was a pioneering decision that was taken by the Court of Justice. But there it is, that's what they said. That's the first point. The second point that I make, and why I rely on this case, is because the basis of the jurisprudence, I say, is from paragraph 22. The court is seeking to adopt an approach to reach a result that is consistent with respecting the dignity and the freedom of the person who is unfortunate enough to have undergone gender reassignment. I mean, this is obviously a serious personal predicament. People go through this process of gender reassignment, and the law says, under community law, under EU law, that we, those who implement the law, are obliged to respect their dignity and freedom. And I respectfully submit that the approach taken here, you must satisfy a marital condition, is inconsistent with respecting the dignity and freedom of my client, who is, in medical and psychological terms, a woman and is entitled to be regarded as one for the purposes of pension law. So that's what I say in relation to the P and S case.
What do we learn from P&S as to who is the appropriate comparator in the present case?
Well, we learn, I would accept little as to who is the appropriate comparator for the reasons that were put to me by my Lord Sumption and by the Deputy President. I mean, it's simply not the issue in that case. The issue in that case is whether you can treat someone less favourably because they are going through a process of gender reassignment. It is Richards that addresses more directly that point that my Lord Hodge puts to me. And I want to come back to Richards because, as my Lord Towson put to me, one does obtain guidance on this very issue from the Advocate General Jacobs. So can I come to Richards, which is at tab 24, which is SC page number 790. And can we go, please, to the advice, the opinion of Advocate General Jacobs and pick that up at paragraph 44, which appears on SC page number 801.
I think you want to start slightly earlier, don't you? Paragraph 38, and then that leads on to
Very well. Let's
P&S.
SC page number 838. The applicant in the present case is denied her pension in circumstances where, yes, thank you, my lord, had she been registered as female at birth, she would have been entitled to it. The alleged discrimination accordingly lies in the UK's failure to recognise a transsexual person in their acquired gender on equal terms with persons recorded as of that gender at birth. Then there's a reference to P and S, and at 40, that follows on. 41, I don't think assists. 42, the Advocate General says that P&S was a particularly clear case for the reasons that we have discussed, and similarly, says Advocate General Jacobs, the decision of the Appellate Committee in A and Chief Constable. And then 44, in KB, which is mentioned by the court, in Richards, the situation was different, arriving at its conclusion that the exclusion of the male to female transsexual partner of a female member of the NHS pension scheme constituted sex discrimination. The court compared the couple to a heterosexual couple where neither partner's identity is the result of gender reassignment surgery, and the couple are therefore able to marry. The correct comparator in the case of the female to male transsexual was therefore a male person whose identity was not the result of gender reassignment surgery. 45. In the present case also, he says, that seems to me to be the correct basis of comparison. The applicant is denied her pension in circumstances where, had she been registered as female at birth, she would have been entitled to it. The alleged discrimination accordingly lies in the UK's failure to recognise a transsexual person in their acquired gender on equal terms with persons recorded as of that gender at birth, precisely the issue in KB. I consider, therefore, he says, the correct comparison in the present case concerning a male to female transsexual person is a female person whose identity is not the result of gender reassignment surgery. And there's a bit more detail, which I invite the court to read in due course. And then at 57, the Advocate General says he would add that the question of the stage at which a transsexual person becomes entitled to equal treatment within the meaning of the directive with persons of his or her acquired gender was debated at the hearing. There is, however, no need to resolve that issue in the Richards case, which concerns a post-operative transsexual person whose entitlement is therefore clear. In other words, what matters, so far as the Advocate General understands it, is whether you are clearly, in that case, a post-operative transsexual, or otherwise a person who clearly you are a woman in medical and psychological terms, as my Lord Wilson pointed out. It's not necessary to have a medical operation. And I say that the Richards case in the court adopts essentially the same approach as the Advocate General. The court at paragraphs 29 to 31, which I've read, similarly adopts the approach that the comparison is with the person born into the acquired gender, whether you are a a woman. The case of Richards states, and I've read it already, paragraph 21, it's SC page number 815, it states that it's a matter for the member state to decide what conditions to impose in relation to legal recognition to the change of gender. This is SC page number 815.
Forgive me,
I've read
Lord Panic.
that, and as the court saw, and as my Lord Wilson indicated, it's helpful then to go to the KB case, which is mentioned in paragraph 21.
Forgive me before you do so.
Yes, sir.
Is there anything said by the court itself rather than the Advocate General as to the appropriate comparator in Richards?
Well, the relevant paragraphs are the ones that I read at paragraph, particularly at 29, which is on SC page number 816.
Yes. So you see that as being, that as agreeing with the Advocate.
In my submission, yes,
thank you.
unlike women whose gender, this is paragraph 29 on page SC page number 816, unlike women whose gender is not the result of gender reassignment surgery, who may receive a retirement pension at the age of 60, Ms. Richards is not able to fulfil one of the conditions of eligibility for that pension, in this case, that relating to retirement age. So I say that's the same approach as to comparison.
Yes.
I'd mentioned paragraph 21, which refers to the case of KB. This was the case relating to the eligibility of the partner to a survivor's pension. And the only relevant passage, I think, although I will happily read others if I'm asked to do so, is we're looking at tab 23, the previous tab, and it's SC page number 788, and it's paragraph 35, where the court says this. It says, since it is for the member states to determine the conditions under which legal recognition is given to the change of gender of a person in our situation, as the European Court has accepted, and there's a reference to Goodwin, it is for the national court to determine whether in a case such as that in the main proceedings, a person in KB's situation can rely on Article 141, right to equal pay without sex discrimination, in order to gain recognition of her right to nominate her partner as the beneficiary of the survivor's pension. Now, that I entirely accept, and this was the point I think my Lord was putting to me, I entirely accept that the court is there acknowledging that the European Court of Human Rights has addressed the general issues of the rights of those who have undergone gender reassignment, and there's a reference to it being for the member state to determine the conditions. I respectfully submit that doesn't answer the question in the present case, because the question in the present case is what limits there are on the power of the member state under the directive to impose conditions.
Well, if we were to chase matters through, if you would be prepared to, go quickly to Goodwin,
Yes.
paragraph 103.
Yes?
As they are mentioned, I think we've got it on 1126 in the memory stick. We see the sort of conditions that the Strasbourg court considered states could impose, and we've got the Luxembourg court apparently importing that, Lord Panic.
Well, certainly the Luxembourg court in KB recognises that the Strasbourg court has looked at this matter. Paragraph 103 appears behind tab 30 in the same volume, and as your Lordship puts to me, it is page 1126. Perhaps we should just look at paragraph 103, which is the passage to which the Luxembourg court refers. It may be noted from the materials submitted by Liberty, although there's widespread acceptance of the marriage of transsexuals, Fewer countries permit the marriage of transsexuals in their assigned gender than recognise the change of gender itself. The court is not persuaded this supports an argument for leaving the matter entirely to the contracting states, as being within their margin of appreciation. This would be tantamount to finding that the range of options open to a contracting state included an effective bar on any exercise of the right to marry. The margin of appreciation cannot extend so far. It's for contracting states to determine inter alia conditions under which a person claiming legal recognition as a transsexual establishes that gender reassignment has been properly effected, or under which past marriages cease to be valid, and the formalities applicable to future marriages, including, for example, the information to be furnished to intended spouses. The court finds no justification for barring the transsexual from enjoying the right to marry under any circumstances. And the issue there, of course, is whether or not someone who has undergone gender reassignment has a right to marry, and if so, under what conditions.
Well, that was what Goodwin was about.
Yes.
But the interesting phrase in paragraph 103 is the conditions under which a person claiming legal recognition as a transsexual establishes that gender reassignment has been properly effected.
Precisely. And that's my point. Of course, the state has the power, and the court may think it's a broad discretion, to decide the criteria for determining whether gender reassignment has taken place. Has it been properly effected? And I say that is a question it's a medical and a psychological question. That's the point. That's the issue. And I, therefore, I'm grateful to the Deputy President that I say 103 assists our argument. And there's some support. I entirely recognise that this is not determinative, but there's an indication in Richards that is how the Court of Justice itself understood the matter. And I've read it already, but can I go back to it? It's in Richards, tab 24, and it's SC page number 819. It's paragraph 38 at the top of the page, where the court's summarising its answer to the first question. The court says at paragraph 38, SC page number 819, it's clear from the foregoing that Article 4 must be interpreted as precluding legislation which denies a person who, in accordance with the conditions laid down by national law, these are the conditions, has undergone male to female gender reassignment. And then the question is entitlement to a retirement pension. So the question is, have they undergone male to female gender reassignment? That's the issue. The conditions must relate to that, not to something extraneous. Now, the answer to these points that my friend gives is the Secretary of State says, and it's in his printed case, but I don't think it's necessary to go to it. He says, if we are correct, if we're right, then it would in effect require the member state to recognise a same-sex marriage in the context of gender reassignment. That's what we would be compelling the state to do. To which my answer is that this case, this issue, is concerned with the narrow question of whether a person is entitled to be recognised as a woman for the purpose of claiming a state retirement pension under the equality principles of Directive 79/7.
Well, the answer which you are rejecting would be quite a powerful response so far as your case is based on the notion that treating a person born female more favourably than a person who becomes female by gender reassignment, the first way that you put it, it may be a much more powerful answer to that way of putting it than to your second way of putting it, which is the introduction of marital status on a pension issue is simply the introduction of an irrelevant criteria.
Yes. Well, I entirely accept that. I'm eager to advance both strands. My answer to the first strand is I accept, as a matter of analysis, my client is in one respect seeking to put herself in a better position than the person born female, because the person born female cannot have a same-sex marriage. But my answer to that is that, with great respect, is not the question. The question is to be focused on entitlement to a retirement pension. That's what this case is concerned about. It's what the directive is concerned about. It's concerned with social security.
If you view this as a problem of indirect discrimination, in a sense your two approaches are reconciled. If it's a question of indirect discrimination, you ask yourself whether there's an objective justification. And the problem about the objective justification relied upon is that it goes to a point which has got nothing to do with pension entitlement.
Well, I respectfully agree, and from my client's point of view, it makes no difference to her whether she wins under one heading or the other. And
Well,
I'm
she can
coming
win on both if one's looking at indirect in relation to the first.
Well,
I wonder whether there is also a broader matter here. When one is looking across the spectrum of social security law, there are an endless number of anomalies between people who are married, same-sex, living together but not married. Long ago, the attempt was given up to have complete consistency and uniformity across the social security sector as compared with, well, both internally and as compared with other things such as holding driving license, what name appears on a driving license, what name appears on your passport, and a number of other things.
Well, indeed, and it's one of the features of this case that my client has long enjoyed, a driving licence and a passport which recognises her as female.
So the argument for consistency has a somewhat shaky foundation.
Well, I would respectfully adopt that, my lord, and the way I put it is that for the purposes of this directive, the relevant question is whether the person born female is subject to any marital condition at all, and she is not. She is entitled to receive a pension at age 60, irrespective of marital status. It is simply irrelevant, and that is the right comparison. It is nothing to the point how a different area of the law, that is marriage, treats my client and treats other people.
I mean, this is not a criticism, but ultimately you're making a short point.
Well, it's a very short point.
I mean, repeatedly in different ways, but
Yes.
they all come back to the same point.
Well, it does. I don't want to tire your lordship, but that is the point. I've got one other point under this first head that perhaps I could make. And my friend's argument really comes to this. He says that the law cannot be required to recognise the appellant as entitled to receive a state pension at the age of 60 when she's married, because that would cut across the prohibition at the relevant time of same-sex marriage. And I point out that this is precisely what happened in both Richards and Timbrell, because before the GRA came into effect, there were two cases that addressed the very question of whether someone who'd undergone gender reassignment and had reached the age of 60 was entitled to a pension at age 60. And one of them is Richards, and the court has seen what the Court of Justice said, and I've shown the court by reference to Timbrell that Miss Richards was in fact married. So although nobody took the point, the consequence of Richards was that she was entitled to a pension at age 60, even though she was in fact married. And the same is true of Timbrell. Can I just take the court to Timbrell? It's volume 1, tab 11. Well, I've made the point already, but if your court would just bear with me. It's volume 1, tab 11, SC page number 482. This is another case where, prior to the coming into effect of the GRA, a person who's undergone gender reassignment reaches the age of 60 and she wants a pension. And the Court of Appeal holds that she's entitled to a pension at age 60 because the GRA doesn't exist, hasn't yet come into force. And it's a striking fact of the case. See SC page number 484, paragraph 1, that Miss Timbrell is married. She's happily married. And the point I make is that if my friend is right, that you cannot be treated as a woman for state pension purposes at the age of 60 because you are married, without fundamentally undermining the lack of same-sex marriage in the United Kingdom at that time, that would equally apply to Timbrell. There is no fundamental objection for the very good reason that the case is dealing with a specific right in a specific context, and that is pension law.
I thought the problem in Timbrell and Richards was that this very important developed social issue simply hadn't been addressed at all by Parliament.
Indeed.
And so when it is addressed, and we have the 2004 Act, it may be a different environment, Lord Bannock.
Well, it's certainly a different environment, but the case against me, one of the main points against me, is that the consequence of what I'm submitting, if right, would be to compel the United Kingdom to recognise my client as a woman for the purposes of pension age, when, because she's already married, that would amount to somehow implicit approval or recognition of a same-sex marriage. And I'm simply pointing out that that was equally the consequence of Timbrell and Richards. At that time, there was no legislation, I entirely accept, but it's equally true at that time that those women are recognised as women, even though they were married at the relevant time. That's what I wanted to say on the first point. Can I move on to indirect discrimination? Our second alternative submission is that the member state may only impose a condition relating to gender reassignment in this area if it's a condition that is not indirectly discriminatory. In other words, it mustn't have a disparate impact on women and not be capable of justification. And we have the considerable advantage in this context that the very condition which is being imposed is a marital condition, which, as the wording of the directive recognises, is something that is at least a very strong indicator of disparate impact on women. The principles of indirect discrimination are very familiar to the court, and I'm not, unless invited to do so, going to take time on that. What the court may just find of some interest are the statistics, because we do have some statistics here. And the statistics are the official Ministry of Justice statistics, which appear behind tab 36 of volume 2 in the Authorities, volume 2. Tab 36 is SC page number 1213. And we see on page 1214, in the middle of the page, the stark figure that in the relevant period, which is January to March 2016, and this is typical of all the quarterly statistics, I've looked back not at all of them, but at many of them, and this is the general position. Of the full GRCs granted, 61% are granted to individuals registered male at birth, who thus became legally female, and 39% are granted to individuals who are registered female at birth. So the process of sex reassignment is predominantly a male to female phenomenon. It's between, if one looks back at those statistics, it's between 60 and 66% each quarter. And if the court turns over to page 1216, one gets the picture back to 2005, 2006, and one can see there why it's about 60 to 60%, because we have at the top of the page the financial year, then the number of total full GRCs granted, and then the gender at birth. And one can see that for each year, it's about 60 to 65% of those who receive a GRC are male at birth. So it's predominantly a male to female phenomenon, gender reassignment. And when we come down to the years 2014 to 2015 and 2015 to 2016, we get a marital breakdown because, of course, before those years, you couldn't get a full GRC if you were married. So that's why there's no statistics before those years. But when we get to 2014 to 15, 2015 to 16, we see that about a sixth of those who get a full GRC are in fact married, or were married. Now, the Secretary of State made a point in his written case. It was paragraph 59. I don't ask the court to turn it up, but he made a point that those statistics do not identify what proportion of male to female gender reassignment and what proportion of female to male gender reassignment were married and what proportion were not married. And that's correct. So what we did was to write an email asking for that information. It may not matter, but just for completeness, I hope the court has a small additional documents bundle which we have supplied. This is new material. My friend has had it, and it's based on the official response. The first document...
No, it's coming.
Thank you. Ah, it's coming.
Thank you.
Thank you.
Thank you.
It's headed Additional Documents. The first page is our, yes, it's our email, which I don't need to take time on. What matters is SC page number 8. This is the response from the Courts and Tribunal Service, a response to our Freedom of Information request, a response with commendable speed, because we told them this matter was in this court today. This response from Diane Merry of the administrative team of the Gender Recognition Panel, she sets out what we've asked for, and she then says she can confirm the department holds information you've asked for. I'm pleased to provide this to you. She says in table 5.4, the breakdown of the 10 married applicants, the 10 is the figure I've just shown the court on SC page number 1216 for 2014-15. The breakdown of the 10 married applicants that were granted a full GRC is male to female, there were 9, and female to male, there was 1. So the marriage condition is predominantly something that affects those who become women. And the breakdown of the interim GRCs, she refers to 123, which doesn't tie in with the figure on SC No, it doesn't time because it's using a different figure, but it doesn't matter. She tells us that there's 123 interim GRCs granted to married applicants which were converted to full GRCs after the marriages were ended. And again, it's predominantly a male-female issue. 101 of those whose gender reassignment resulted in them becoming women, 101, those who became male is 22. So to the extent that it matters, again, that picture confirms that the marriage condition is predominantly, not exclusively, predominantly something that affects those who become women. And we say all of that is more than enough to establish a need for the Secretary of State to justify the marriage condition. And our submission is that the Secretary of State cannot justify the marriage condition to which we object. And the reasons why the Secretary of State cannot justify the condition to which we accept are, first of all, for the reason put to me by my Lord Sumption, that the Secretary of State is not tailoring the justification to a sufficient extent. The Secretary of State and Parliament have adopted a broader approach when what matters in the present context is simply the question of justification in relation to pensionable age for the purpose of receiving a retirement pension. And there's, I say, no justification, if one looks at the narrow question, for not recognising my client as a woman when plainly, medically and psychologically, she is a woman. That's the first point. Secondly, and I've made this point already, the Secretary of State is imposing a marriage condition which frustrates the object and purpose of the law in this context, which is to recognise the dignity of a person who has undergone gender reassignment and who is, in medical and psychological terms, a woman. Thirdly, and this is an argument that applies to the circumstances of this case, but it would apply to any case in which the condition matters, the marital condition, that is that what the marital condition does is to impose upon my client and others like her a stark choice. Either you have your gender, your new gender, your required gender recognised for the purposes of pension law, either, let me start again, either you terminate your marriage by divorce or annulment, or your gender will not be recognised for the purposes of your pension. You will not be recognised as a woman, even though medically and psychologically you are a woman. You will not be recognised. And that, I say, is fundamentally objectionable in circumstances where the appellant and her wife are, as the statement of facts recognises, opposed for religious reasons to divorce or annulment and do not wish to end their marriage.
Is that third point part of the second point, or is it a separate point?
It's a separate point. I mean, it's part of the second point in that it goes to dignity.
The second point is at a very general level, and
Yes.
you haven't specified it further. I could see you could put the third point within the second point.
I respectfully agree.
Aren't you in some difficulty advancing this particular limb, the human dignity point, when you have perfectly understandably disavowed any human rights limb to your argument? I mean, the arguments under Article 8, etc., are completely based upon protection of human dignity, autonomy, etc., etc. So to jettison your human rights points, acknowledging the force of the Finland case, but then try to resurrect it in this part seems to me to be a little questionable.
Well, I have to accept before this court, were I to argue a case under the Human Rights Act, I would be met with the judgments of the Strasbourg court. I don't accept those judgments as correct. Were I to be arguing this case in the Strasbourg court, I would seek to persuade the court they were wrong, and I would respectfully submit to that court, and I do submit to this court, that the dissenting judges in the Finland case presented very powerful arguments as to why the applicant's case was correct.
Well, I'm wondering where this takes us, because on the one hand you're disclaiming any human rights reliance, but on the other hand you're advancing what is in fact a pure human rights point. And it may be, therefore, that to evaluate this part of your argument, one would need to get into the area which we're not into and look at those authorities.
But the reason we're not into them is twofold. It's first because this is a case purely concerned with the application of the directive and the right to equal treatment in that context by reference to the EU law principles. That's the first reason. The second reason is that this court is not bound by what the European Court says, even if this were a human rights case, all the less so, I would respectfully submit, where the issue is not a human rights question. It is an issue...
Well, I follow that, but what I'm suggesting, you can't really just dip your toe or ankle in the water. Either you plunge into it or you don't.
Well, I don't want to be accused of cowardice, and I will take the court to what the Grand Chamber said in a moment and make my points. But I am submitting that the Luxembourg jurisprudence, CP&S, does emphasise dignity. It's not my only point, it's not even a crucial point, but it's part of the analysis.
Yes. Sorry, the reason why combating sex discrimination in the relevant fields has been a fundamental principle of European Union law from the word go is because of respect for the equal dignity of men and women. That's the reason for it.
Well, indeed.
That's not a human rights argument, that's a EU law fundamental principles
I
argument.
respectfully agree, and the court has made that very clear in both P and S and in Richards when dealing with the issues raised by those who've undergone gender reassignment. However, I do accept that the Strasbourg court, I say inadequately, has addressed in the Finnish case an argument about sex discrimination, about equal treatment. And so I have to accept that, and I therefore have to accept that there is jurisprudence from Strasbourg which doesn't help me, and that I think is the point that my Lord is putting to me. But I respectfully adopt, of course, what the Deputy President says to me. Perhaps we should just look, I don't want to be accused of beating about the bush. Should we just look at the Finnish case, Hämäläinen and Finland, which is in Volume 2, tab 32. And we have two judgments in tab 32. It starts at SC page number 1150. And we have two judgments there. First, we have the judgment of the fourth section, which starts at 1150 and goes to 1164. And then we have the judgment of the Grand Chamber, which starts at 1165. And in that judgment, the applicant is named, the anonymity has gone, and that continues to the end of the tab, page 1204. And the court deals with a number of issues. It deals in particular with the Article 8 issues, and the substance of it, I think, there's a lot of it, but the substance of it appears at page 1187, paragraph 87. And at 87, they say, while it's, and I should emphasise, because my friend makes this point, this is another case where the individuals concerned have religious objections to ending their marriage. That appears at paragraph 15 on page 1168. I don't want to be accused of taking a false point. But at paragraph 87, which is page 1187, the court says, while it's regrettable the applicant faces daily situations in which the incorrect identity number, that was her complaint, she couldn't get an identity number in the female gender, creates inconvenience for her, the court considers the applicant has a genuine, paragraph 87, page 1187, the applicant has a genuine possibility of changing that state of affairs. Her marriage can be converted into a registered partnership with the consent of her spouse. If no such consent is obtained, the possibility of divorce is always open to her. And of course, in our case, the appellant could get divorced. If she got divorced, or there was a decree of nullity, she could enter into a civil partnership at the relevant time. Of course, she didn't want to, because she didn't want to end the marriage for religious reasons. In the court's view, it's not disproportionate to require as a precondition to legal recognition of an acquired gender that the applicant's marriage be converted into a registered partnership, as that is a genuine option which provides legal protection for same-sex couples that is almost identical to that of marriage cited above. The minor differences between the two legal concepts are not capable of rendering the current Finnish system deficient from the point of view of the state's positive obligation. And that we would respectfully dispute. It ignores, in a case such as the present, the fundamental objection of my client and her spouse to ending their long-standing marriage. They have a religious objection to doing so. It is nothing to the point that they could, on ending the marriage, have entered into a civil partnership. It simply doesn't address the objection that they have, nor, of course, is it dealing with anything relevant to EU law concerning equal treatment. Where they do address equal treatment, and I say address it entirely inadequately with great respect to them, is when they come to Article 14. And Article 14 is addressed at SC page number 1191. And the complaint is set out at paragraphs 103 to 105, where the appellant, the applicant, argues that she had to comply with an additional requirement of terminating her marriage in order to obtain legal gender recognition. She's therefore discriminated against vis-à-vis cisexuals. That's those who are born into the gender that they retain, who obtained legal gender recognition automatically at birth without any additional requirement. And secondly, the applicant, her wife and child receive less protection than persons in heterosexual marriages owing to stereotypical views, a different point. And the court deals with this at paragraph 110 on page 1192. And it's paragraph 111. The court notes that the applicant's complaints under Article 14 relate to her request for a female identity number and to the problems she's experienced in that respect. In her complaints, she compared her situation to that of cisexuals who had obtained legal gender recognition automatically at birth and whose marriages, according to the applicant, did not run the risk of forced divorce in the way that hers did. 112 over the page. The Grand Chamber agrees with the Chamber that the applicant's situation and the situation of cisexuals are not sufficiently similar to be compared with each other. The applicant cannot therefore claim to be in the same situation as cisexuals, to which the obvious riposte is, why not? With great respect. And one then has a dissenting opinion at page 1196 of 3 judges in the Grand Chamber, which I respectfully commend to this court, starting at 1196, and I can just pick out 1 or 2 passages. Under preliminary remarks, in my submission, they get the right starting point, because they say, paragraph 2, the starting point is that one's gender identity is a particularly important facet of individual existence, and states are required to recognise the change of gender undergone by transsexual individuals. And then page 1198, in paragraph 6, picking it up in the 3rd sentence, they say, furthermore, it's our view the majority did not sufficiently take into account the fact that the applicant and her spouse are deeply religious. They believe that the marriage will last for life. Given their religious background, the applicant and the spouse cannot simply change their marriage into a same-sex partnership, as this would contradict their religious belief. We regard the majority as not take important factual information sufficiently into account. And we say the same is true here. That goes vitally to dignity. Paragraph 8, they say the applicant has an interest in being granted a female identification number, otherwise she's required to identify herself as transgender, thus reveal an aspect of her personality belonging to a most intimate sphere. This is more than a, quote, regrettable inconvenience. I respectfully agree. And then if we travel down about 12, 15 lines, on page SC page 1199, second, says the dissenters, the alternative offered to the applicant, namely the conversion of her marriage into a same-sex partnership, is not an option, and that's because they have a religious conviction which doesn't allow the transformation of their relationship into a same-sex marriage. And then at 1200, paragraph 10, we submit the rights and freedoms of others would in no way be affected if the applicant and her wife were permitted to remain married despite the applicant's legal change of gender. Their continued marital relationship would not have detrimental effects for the rights of others to marry or for existing marriages. Paragraph 12, about 8 lines down, in our view, the institution of marriage would not be endangered by a small number of couples who may wish to remain married in a situation such as the applicant. And over the page, finally, 1201, in this vein, we note, since the applicant and her wife continue to be married at the time of this judgment, they currently present themselves to the outside world as 2 individuals with female gender expression who are united in a legally valid marriage. In other words, they continue to live together as a married couple, perfectly in accordance with the law, notwithstanding the fact that in the eyes of many people they are a same-sex couple. The applicant's change in gender identity being a fait accompli, it's difficult to comprehend why the legal recognition of her acquired gender will have any significant additional impact on public morals. I respectfully agree. So if my Lord, as he does, my Lord Torson understandably puts to me, well, if I'm relying on dignity, what about the human rights cases? I respectfully submit that the reasoning of the Grand Chamber, most respectfully submit that the reasoning of the Grand Chamber, particularly on sex discrimination, is wholly inadequate, and the dissenting judgment is a very powerful one. But I'm not arguing a human rights case here. I don't need to. I don't need to because I am relying on the directive. This is a case about EU law. And although, of course, I accept that EU law takes account of the convention is not binding in domestic law. And even if it were a human rights case, nor, I say, in a case about the directive, should this court feel itself to be bound by Strasbourg. I'm either right or I'm wrong in the submissions that I make. And I have a further point in relation to justification after I've dealt with dignity. We do draw attention to the fact, and it is a fact, that the marital condition is only being imposed in the appellant's case because of the date when she reached the age of 60. It is striking that had she reached the age of 60 earlier, by which I mean before the GRA came into effect on the 4th of April 2005, she would have been entitled to a state pension at the age of 60 under Richards and Timbrell, even though she was married. And if she'd reached the age of 60 later, by which I mean after the GRA was amended by the Marriage Same-Sex Couples Act in 2014, again, she would have been entitled to a pension age of 60 without having to end her marriage. So the marriage condition only applies to this intermediate group. There can't be many people, we are only aware of one or two others, of whom it is true that they are women who reach the age of 60 between those dates, that is between 4th of April 2005 and 10th of December 2014, who have undergone gender reassignment, who are married, and who are unwilling, for religious or other reasons, to end the marriage. So it's
a small class of people.
Very small class of people.
Yes, but the fact is, whatever the situation was before the legislation, and whatever the situation was after the legislation was amended, our task is to look at the legality of the legislation
I entirely accept
while it was in force.
Of course.
So we can't separate this from the history of the legislation.
No, but it does go to the question, I submit, of whether there is some fundamental objection that answers the force, if your lordship thinks there is any force, of the points that I seek to make. And I've made the point already that the Secretary of State's response is that the objective justification seeks to protect the principle of English law until 2014 that there cannot be a same-sex marriage. My answer is twofold. First, is the point that my Lord Sumption puts to me, that is too broad an approach that Parliament has adopted. And my second answer is there was no fundamental objection in the Timbrell and Richards cases when a woman, gender reassigned woman, is treated as having a pension age of 60, even though she was at the time married. And I've also made the point, matter for the court how far it goes, but it is striking in this case that although the appellant is married, the state has had no difficulty in recognising her as a woman for the purposes of official documents, that is her passport and her driving licence. There's no dispute about that. It's set out it's stated in the Statement of Facts and Issues, paragraph 4.
Mr. Coppell says that they're not gender dependent, Lord Panic.
Well, they are gender dependent in the sense that they identify your passport and your driving licence, whether you are male or female, and she has been issued with documents that record her for those official purposes as female.
But that's purely descriptive. It makes absolutely no difference to the rights which those documents confer.
I don't suggest that any legal right depends on it, but nevertheless, the state, when it describes her, is prepared in those official documents to recognise her as a woman, despite the fact that she is married to a woman. But I take the point. That's why the point only travels so far. There's no specific legal right that is consequent upon it. But it does show that the state is perfectly capable, when it wishes to do so, of recognising my client as a woman even though she is a married person. Unless there are other matters that the court would wish me to deal with, that's what I wanted to say on behalf of the appellant.
It appears there are no further matters.
Much obliged.
Thank you, Lord
Lady.
Panic. Miss Bretherton, how very good to see you in this court, also in silk.
Thank you very much.
Thank you, my lady. My lords, we say that this appeal faces insurmountable obstacles, which I will summarise. In substance, the appeal is a challenge to legislation, what the parties have referred to as the marriage condition, which was designed to prevent same-sex marriage, and indeed still does so in one part of the United Kingdom where same-sex marriage is not permitted. That's section 4.3 of the Gender Recognition Act, which I believe is that which is objectionable. Lord Panic said it was section 3. I think it's section 4.3. The appellant accepts, then, that the prohibition by domestic legislation at the material time of same-sex marriage was compatible with ECHR law and also with EU law. No challenge to the general policy. The marriage condition was an obvious precaution, we say, to maintain the integrity of that prohibition, and such a condition has been upheld by the Court of Human Rights in 4 different judgments, including a recent judgment of the Grand Chamber. We say that there is no basis for supposing that EU law and the directive could confer upon the appellant different and greater rights to legal recognition of her acquired gender than does the ECHR. This is a context where, as I will show you from the authorities, EU law has followed the ECHR. Lord Panic said on a couple of occasions, this is not a human rights case, but it is. It is a human rights case. Under EU law, it is a human rights case because it is human rights which have driven the Court of Justice to the conclusions which it has reached in the key authorities. So this is a context where EU law has followed the ECHR and where, in particular, the Court of Justice has followed the Court of Human Rights in making clear that the conditions for legal recognition of an acquired gender are for member states to determine and are not determined for them by EU law. Finally, then, we say that after human rights arguments have been disposed of, and they are disposed of by the judgments of the Court of Human Rights, there is no further question of justification under the directive or otherwise. We don't accept, for example, that there's any direct or indirect discrimination in this case for reasons that I'll come on to. If there is a need to provide further justification beyond the human rights cases, I understand the way the case is put by Lord Panic today is that the appellant objects to a blanket rule, a rule which is not sufficiently tailored because legal recognition is given by the Gender Recognition Act for all purposes which matter in law, and not only for some purposes. He says the line should be drawn in a different place when it comes to pension than it is drawn in other places for legal recognition more generally. And we say in response to that, that Parliament had a broad discretion and it was entitled to adopt what we customarily call a bright line, whereby either an applicant obtains legal recognition for their change of gender or they don't. And different legal contexts are treated in the same way. We say that was a legitimate approach, which can't be called into question.
It is common ground, is it not, Mr. Coppell, that the directive has direct effect?
Yes, it is. This
Yes. So that if,
provision.
for the sake of argument, Lord Panic is correct in his argument, well then the marriage condition has to be disapplied for the purposes of pension entitlement. That is all.
Well, Lady, it is certainly accepted that if Mr. Panic is right, the marriage condition would fall to be disapplied. I think there may be something of an issue as to the particular context in which that condition would fall to be disapplied. We would say what the appellant should have done if she wished to challenge the marriage condition was to apply for a gender recognition certificate and to submit to the panel that she ought to be granted a full certificate because the marriage condition, which permitted her only to have an interim certificate, was unlawful.
Why would that have been a better way of bringing this to a head than the way in which it has been brought to a head?
Well, because as matters stand under the social security legislation, the Secretary of State has no option had no option but to refuse the application because a gender recognition certificate had not been issued, hadn't even been applied for, in fact.
That would be contrary to the logic of the main argument that MB is seeking to put forward, because the main argument, as I understand it, is not that there's an objection to a bright line rule or to a process of certification as such, but simply an objection to the use of a particular criteria for a purpose for which it's irrelevant. Now, if that is the argument that is to be run, there's no reason why they should run a much more radical and fundamental argument of the sort that you would require them to do.
Well, Lord, certainly I accept that if the argument is going to be that the appellant should have her pension without having to get a gender recognition certificate at all, that the whole of the Gender Recognition Act scheme shouldn't be applied to her. If that's the argument, then yes, I accept what my lord is saying. She can go to the Secretary of State and she can say, I want my pension. I don't have a certificate. I can't satisfy the conditions of the Act, but I don't need a certificate. No, yes.
But the absence of a certificate on this particular ground, namely marital status, is not one that can be relied upon as depriving her of the pension right at 60. I think that is the point that's being made.
Well, Lord, as I say, if the challenge has become a root and branch attack to the need for a certificate at all, yes, I accept that. If the argument was more narrowly focused, as we understood it, and was to the effect that she should be able to get a certificate without needing to satisfy the condition, then the answer is different. We submit the appropriate course was to obtain a certificate in reliance upon the directive. And then the social security legislation falls into place, and the Secretary of State must grant the pension as opposed to must not grant the pension, which was the actual position. But in substance, and going back to my lady's question, it's not disputed that the marriage condition would fall to be disapplied in reliance upon the directive. I'm simply making a point as to context. So what I would like to do first, then, having summarised our case, what I would like to do is to go back through the authorities to show where we have got to, and with the way Lord Panic now puts his case firmly in mind, and there are certain additional passages that I would like to show you. The line of authority starts with Goodwin, please, tab 30, page 1097. Paragraph 17 on page 1101 tells us that as has very often been the case, continues to be the case in transsexual litigation, eligibility for state pension is a key issue, and it was an issue in Goodwin as part of the factual background of the case, and was one of the many complaints which she made as regards her treatment by the state. So she had reached the age of 60, but was informed by the then DSS that she didn't qualify for a pension, and she'd have to carry on making contributions until the age of 65. And a number of other instances are referred to in this passage in these paragraphs, including in relation to birth certificates, claiming winter fuel allowance, paying higher motor insurance premiums, a whole different range of contexts in which the non-recognition of her acquired gender caused difficulties. Paragraph 78 then, on page 1118, the court will have seen the reference in KB, and I think also in Richards, to gender reassignment having been carried out in accordance with the conditions laid down by national law. And perhaps wondered what that meant in circumstances where there weren't any conditions laid down by national law at that point. What I think it means, what we submit it means, it's a reference back to paragraph 78 of Goodwin, and to the point that which one sees about 6 or 7 lines down, that gender reassignment had been lawfully provided by the National Health Service. In fact, and the court, and perhaps in contrast to other countries where gender reassignment surgery was unlawful at the time, and the court says at the end of the paragraph that it seemed illogical for the state to authorise the treatment and the surgery for gender reassignment, but then to refuse to recognise the legal implications. But that's the reference to national law we submit. And going through to paragraph 89 on 1121, this is the start of the passage and the court's findings in relation to Article 8, and there's reference in the first part of paragraph 89 to the various difficulties and anomalies of the applicant's situation. I showed you some of those earlier on, and paragraph 90, the very essence of the convention being respect for human dignity and human freedom. And going over the page, at the end of paragraph 90, the court says, in short, the unsatisfactory situation in which post-operative transsexuals live in an intermediate zone, is not quite one gender or the other, is no longer sustainable. And it refers to the Interdepartmental Working Group in the Court of Appeal's judgment in Bellinger. And paragraph 91 and 92, the court goes into then the sorts of reforms which would have to be made were the UK to comply with its obligations under Article 8. Major changes to the system, applying to birth registration, access to records, family law, filiation, inheritance, social security and insurance. And there's reference to state pension further down the paragraph, nor is the court convinced by arguments that allow the applicant to fall under the rules that applicable to women, which would also change the date of eligibility for her state pension, would cause any injustice to others in the national insurance and state pension systems, no concrete or substantial hardship or detriment to the public interest, and so forth. And then paragraph 92, there's reference to the UK having kept the matter under review, issued a report, but then it being said that no legislation was going to be taken forward. But all of this and the reason why I draw this section of the judgment to your attention is that it's of a piece with what one then sees in paragraph 103 in terms of the court recognising that these are difficult questions which can be dealt with by the UK, but will cause a lot of work and will require legislation. And when it comes then to paragraph 103, where you have the specific point about the sorts of changes that national law is going to have to make when conferring legal recognition of the new gender, that we say is all consistent with what the court has recognised when it's ruling on Article 8. And it finds a breach of the Article 8 positive obligation, as we know. That's in paragraph 93. And then when it comes to the marriage, to the right to marriage under Article 12, the court refers in paragraph 102 on page 1125 to the government's argument that in this sensitive area, eligibility for marriage should be left to the domestic courts, adverting to the potential impact on already existing marriages in which transsexual is a partner, and best handled by the legislature. So said the Court of Appeal in Bellinger. And then paragraph 103, which you have seen, and we say that the court, in the sentence beginning, while it is for the contracting state to determine inter alia the conditions under which a person claiming legal recognition as a transsexual establishes that gender assignment has been properly effected, or under which past marriages cease to be valid and the formalities applicable to future marriages. This is a composite recognition. I appreciate Lord Panic, in answer to a question from my lady, sought to separate out the first clause, conditions under which a person claiming legal recognition as a transsexual, so forth, to separate that out from conditions under which past marriages cease to be valid and formalities applicable to future marriages. We say it is all to be read as a piece, and in the light of what the court has already found in relation to Article 8. And there's certainly no suggestion, and this will be a theme of my submissions, there's no suggestion in Goodwin that the legal conditions for recognition of an acquired gender should be, or even could sensibly be, different in different contexts. It's all of the piece. There's a whole range of problems which have to be addressed. You lay down your conditions for legal recognition, and you do it across the piece. The next case, then, more briefly, is KB, tab 23749. And we refer, in addition to what Lord Panic has showed you, we refer to paragraph 30, beginning on 786, and 31. So paragraph 30 is a finding of inequality of treatment, not directly undermining enjoyment of a right, but affecting one of the conditions for the grant of that right, affecting the necessary precondition for the grant of a survivor's pension, namely the capacity to marry. And in the United Kingdom, by comparison with a heterosexual couple where neither partner's identity is the result of gender reassignment surgery and the couple are therefore able to marry, as the case may be, have the benefit of a survivor's pension, which forms part of the pay of one of them, a couple such as KB and R are quite unable to satisfy the marriage requirement as laid down by the NHS pension scheme for the purpose of the award of a survivor's pension. And it's the quite unable point, and it's a point which comes up in later judgments as well. It was completely impossible under the state of UK law as it then stood for this couple to acquire the right to a survivor's pension under the NHS pension scheme, because you needed to be married and you simply could not get married in their situation. This is not at all concerned with and doesn't evidence any concern of the directive to deal with the far more nuanced situation where it is possible to satisfy the legal conditions for the benefit which you wish to obtain, but you have your own objections to meeting those conditions. And you see in para 32 the reference to it being impossible for them to marry and why. And then paragraph 33, one sees reference to Goodwin and the Court of Human Rights having held the fact that it's impossible for a transsexual to marry a person of the sex to which he or she belonged prior to gender reassignment surgery, which arises because for the purposes of registered civil status they belong to the same sex, was a breach of the right to marry. And then the conclusion of the Court of Justice, again, is crucially tied to what the Court of Human Rights had found in Goodwin. 34, legislation such as that in issue in the main proceedings, which in breach of the ECHR, prevents a couple such as KB and R from fulfilling the marriage requirement, which must be met for one of them to be able to benefit from part of the pay of the other, must be regarded as being in principle incompatible with the requirements of Article 141. And that's one of the passages that I rely on when I say that Lord Panic is wrong to submit that this isn't a human rights case. All of this line of case law from the Court of Justice is based on human rights case law. And one sees also that in paragraph 35, which Lord Panic did show you, and it's the point that I rely on, paragraph 103 of Goodwin, for the member states to determine the conditions under which legal recognition is given to the change of gender of a person in ours situation. And again, no suggestion that legal recognition ought to be specific to this context or indeed could be specific to this context rather than applying across the board. So that's KB. Richards then in the following tab begins at page 790. And just a few additional passages I wanted to draw to your attention. The first is paragraph 800, on page 811. One sees the Court of Justice specifically advert in paragraphs 8, 9 and following to the Gender Recognition Act. So at the time material to Richards, there was no avenue for acquiring legal recognition of the new gender, but the court adverts to the Gender Recognition Act, which has been adopted and which is coming into force. And paragraph 20 on page 814 is the beginning of the key ruling of the court, and I refer to paragraph 21, which Lord Panic has showed you, and it's the reference to KB, and it's for the member state to determine, in the context of the right to the retirement pension, the same context as we have here, the conditions under which legal recognition is given to the change of gender of a person, and plainly no express restriction and no hint of any qualification on the right of member states to determine those conditions. And the vice of domestic law in Richards, as we know and is made clear in paragraph 28, is the inability, or as in KB, the impossibility to have the new gender which was acquired following surgery recognised with a view to the application of the Pensions Act. So 29, as Richards simply is not able to fulfil one of the conditions of eligibility, i.e. to demonstrate that she is legally a woman at the material time. And again, we say no suggestion of the court dividing up the circumstances in which legal recognition should be given, should not be given, the conditions which should apply in one context or the other. The vice is simply there were no circumstances in which the acquired gender could be recognised, and that is no longer the case. And one sees that also from paragraph 31, reference back to KB, national legislation which precludes a transsexual from fulfilling a requirement which must be met in order to be entitled to a right protected by community law, must be regarded as being incompatible with the requirements of community law. Timbrell, then, interpreting Richards, volume 1, tab 11, page 482. There isn't any dispute between us as to what Timbrell decides. Lord Panic relies upon Timbrell as demonstrating that the world does not end if somebody who is married is also entitled to claim their state pension at 60. And of course, we accept that was the facts of Timbrell, and that was the facts of Richards as well, albeit nobody took any point about it at the time. But crucially, and as was put to Lord Panic in argument, this all relates to a period before the UK had exercised its discretion, indeed obligation, to put in place the conditions for legal recognition of the new gender. Once Parliament has decided what those conditions shall be, it would undermine parliamentary intention, the scheme of domestic law, in an offensive way. Were a claimant to be recognised as having a right to a pension as a woman, even though she was still married. But so it's a temporal point. Timbrell is clear about what Richards decides, and it's in particular paragraph 41 and 42 and 43, beginning on page 493, where Lord Justice Aiken says, it seems to me the critical question is whether the directive, in particular Article 4, applies to a situation where, as was the case prior to the 2004 Act, English law and legislation had no means at all of giving legal recognition to a change of gender of a person who'd successfully undergone gender reassignment for the purposes of seeing whether that person has reached retirement age for the purposes of obtaining a retirement pension. Was the UK bound to ensure that, with regard to those who had acquired a different gender, there would be no discrimination whatsoever, either direct or indirect, on the ground of sex, with regard either to the scope of the Category A pension scheme or the conditions of access to that scheme? I think the wording of para 38 of Richards provides a clear and definitive answer. It states in terms that Article 4.1 of the directive is to be interpreted as precluding legislation which denies a person who has legally undergone gender reassignment surgery, and legally, in brackets, reference back to Goodwin, say, from entitlement to a retirement pension because she has not reached the age of 65, when that person who'd become a woman by the gender reassignment surgery would have been entitled to that pension at the age of 60 had she been held to be a woman as a matter of national law. In short, as I read para 38 in the Richards case, Article 4.1 precludes, on the grounds that it's either directly or indirectly discriminatory, a situation where there is no legislative or other legal means to give recognition to a person's acquired gender. That's what Richards decides, and para 43 supports our position on this appeal. Mr. Johnson is correct in arguing that the decision in Richards does not indicate what kind of national legislation should be in place or what sort of conditions ought to be satisfied for the recognition of an acquired gender by means of gender reassignment. That is because, as para 31 recognised, that is a matter for national law and not for the Court of Justice to determine. That cannot alter the fact that the case effectively held that a total lack of any kind of legislative framework in UK law to enable acquired gender to be recognised constituted discrimination contrary to the directive. So, as I say, I don't think there's any dispute between us as to what Timbrell decides, indeed as to what Richards decides, and I rely on para 43 as referring to the situation in which we are now in, where Parliament has spoken as to what conditions need to be satisfied. That's a matter for national law and not for the Court of Justice to determine. Two other cases that I need to go to in my canter through the authorities before I come to make my submissions on Lord Pannick's arguments. And those are the cases on the marriage condition. Parry, tab 31 of volume 2, page 1136. So this is a case which is directly about the same provision which is under challenge in these proceedings. 1137, one sees that in the third paragraph, the applicants got married in 1960, have had children, they remain lawfully married, have deep religious convictions. The first applicant was ordained as a church minister. The first applicant underwent gender reassignment, and one sees about the middle of the page the second applicant has stood by him. They remain as a loving and married couple, and at the bottom of the page, neither applicant wishes to annul their marriage, so the first applicant is unable to obtain a full gender recognition certificate. This isn't a case where there was any issue as to social security benefits or other inconveniences of day-to-day life. It's simply about the marriage condition as a bar to obtaining legal recognition of the change of gender. It's a case of strong religious beliefs. The reasoning of the court, I could direct you to the submissions of the parties on 1143 to 1144. I won't read them out. These are effectively the submissions which the parties in the case before you now
This is
make.
an Article 8 complaint.
This is first of all Article 8, and then yes,
Article 12.
then Article 12. But it's Article 8 at this point, and one sees the proportionality argument of the applicants on page 9 in the middle paragraph. No connection between the aim of the measure and the steps taken to meet it. You could allow subsisting marriages to continue on a deemed basis. And then there's a complaint about the status of civil partnerships. And the court's ruling, 1145, accepting that the applicants are in a quandary, as it says, the first applicant must invidiously sacrifice her gender or their marriage. In those terms, there is a direct and invasive effect on the enjoyment of the right to respect for private and family life. And really the crux of the ruling is 3 paragraphs up from the bottom. In the present case, the court notes that the requirement that the applicants annul their marriage flows from the position in English law that only persons of the opposite gender may marry. Same-sex marriages are not permitted. Nonetheless, it is apparent that the applicants may continue their relationship in all its current essentials and may also give it a legal status akin, if not identical, to marriage through a civil partnership, which carries with it almost all the same legal rights and obligations. It is true that there will be costs attached to the various procedures, however the court's not persuaded that these are prohibitive or remove civil partnership as a viable option. So the court recognises the quandary, it recognises the strong religious beliefs, but given the public policy against same-sex marriages and given the alternative of the civil partnership, and that's crucial, and there hasn't been much said by Lord Panic about that, given the alternative of a civil partnership, it is not disproportionate to apply the marriage condition. And there's a further ruling under Article Article 12 on page 12, and the court recognises that it refers to Goodwin, recognises that the UK has now sought to comply with Goodwin through the Gender Recognition Act, has provided a mechanism, this is the middle paragraph on the page, has provided a mechanism for a transsexual to obtain recognition in law of the change and be able to marry a person of the new opposite gender. The court observes that the legislature was aware of the fact there were a small number of transsexuals in subsisting marriages, but deliberately made no provision for those marriages to continue in the event that one partner made use of the gender recognition procedure. And then reference again to the prohibition of same-sex marriages, and reference in the final paragraph on the page back to paragraph 103 of Goodwin. The court cannot but conclude, therefore, the matter falls within the appreciation of the contracting state as to how to regulate the effects of the change of gender in the context of marriage.
There's quite an interesting point at the end of that paragraph, top of 1148, 5 lines down. The applicants stressing the importance that they attach to marriage, but society, conversely, stressing the importance which they attach to marriage at that time being that it should be between different sexes. Yes?
Yes, indeed, my Lord, I adopt that, and I'm going to show the court after the short adjournment some previous authority of the House of Lords, which also emphasises the special status of marriage in the context of transsexuals, and indeed its status as society then regarded it. So yes, ungrateful. So what I will do after the short adjournment, if I may, is to go briefly to Hämäläinen, some additional passages, and then I'll come to my submissions on the justifiability of the marriage condition.
Well, that's a very convenient point which you've reached at this moment. We'll look forward to hearing from you again at 2:00.